back to the presentation. So what the Register of Wills can do for you, we can store your original wills for safekeeping. And like I said, just for the sake of the recording, if you take one thing home from our presentation today is that you should have a last will and testament, and that preferably should be drafted by an attorney. So once you have your attorney draft your will, you can store it in my office for safekeeping for a fee of $5. It's held confidentially until you return it, or excuse me, until you retrieve it, or you pass away and it's used as part of your estate probate proceedings. So for a fee of that $5, it's a really great deal. And there's a lot of benefits to storing it in my office as opposed to storing it at home in your important documents. And I'll run through those a little bit later in our presentation. So the other thing that you can do in our office is open an estate for a deceased relative. And what I mean by open an estate is to initiate a probate proceeding. And when I say probate proceeding, I got some feedback. I'm not sure if it was an echo or someone was trying to ask a question. What it means to open a probate proceeding or open an estate is, and I'm going to give you a brief example. When you pass away or someone passes away and a family member goes to the bank to try to transfer assets. Hang on just a second. I'm getting some weird, it's an echo on my end and it's making it really hard for me to.
Yeah, let's go into goddamn questions.
Okay. Okay, so if someone passes away and a family member goes to the bank to transfer assets from a checking account to a beneficiary in an estate, the bank personnel will say you can't do that unless you have a letters of administration. And you need to, in order to get a letters of administration, you need to come into the Register of Wills and initiate a estate proceeding. And basically you fill some paperwork out. The person who wants to be appointed as personal representative will sign a form explaining that they have priority to be appointed. And that person then will have the job of administering the estate. And what that means is accounting for all the assets, listing all of the people who have an interest in that estate, all the children of the decedent, other relatives that might be beneficiaries of that estate. They have a duty to account for the assets, pay bills, and then ultimately distribute those assets according to the decedent's or the person who passed away last will and testament, or if they don't have a will, according to the Maryland default provisions, and those are called the laws of intestacy that direct where your money goes when you don't have a will. And that whole process is called probate. And when we say open an estate, that's the process we're talking about, filing that paperwork to initiate those estate proceedings. And when you do that, you get what's called a letters of administration. So the personal representative will get a letters of administration that can be used to go to the bank and transfer assets. The other thing the office does is you can access public records related to Maryland estates. So you can view all the documents that have been filed in estates in Maryland, and we have access to those documents and records in the office. You can also access those online, but that's what our office can do. And basically to receive all the services related to carrying out a decedent's wishes in his or her last will and testament. So that's what the office does. So as I was saying, one main point today is that everyone should have a will. And a will is a document that you write that expresses what you want to have happen to your things, your property when you pass away, who you want it to go to. In order to be valid in Maryland, a will needs to be signed by the person making the will. We call that person a testator. Signed by the person who drafted the will and 2 adult witnesses who are competent. So, and then if you have it signed by yourself and 2 witnesses, then you have a valid will. And I get a lot of questions about whether you should go to a lawyer or can you do it yourself. And while the execution requirements are pretty simple, we have probated wills that were written on napkins or greeting cards, but that's really not the best practices. We see a lot of issues with people when they draft their own wills, making errors or inadvertently leaving out important provisions. And that can cause expense and litigation and basically difficulties with your family going forward if your will is not drafted by an attorney. And in this program, on the last slide, there's some resources of where you can look to find an attorney that you can afford who might be able to assist you with doing drafting a will and doing estate planning. So it's a list of attorneys that have volunteered to be put on the list. We aren't advocating one over the other. We put out and Josh was integral in getting this taken care of or spearheading this effort, reaching out to the local bar and getting people to give their name and attorneys to give their name and address to be put on the list. And many of them have listed their hourly rates or their fees. Many have agreed to reduce their fees for referrals from the list from my office. So you can take a look at that list. There's also, if you are income qualified, Maryland Legal Aid has a pro bono estate planning service. So pro bono means free, so a free of charge estate planning services for people who have low income. So we have that resource. We have the Baltimore County Bar Association lawyer referral on that list. And we also have a list of private attorneys who have agreed to be put on that list. And you can look at their hourly rates and see who might fit your budget. So it shouldn't be expensive, but it will save money down the road if it avoids legal fees and conflict in your family. So it's better to pay the few $100s up front than to spend thousands of dollars in legal fees down the road. So what is an estate and what is probate? So an estate, and this is all of the, so the assets that are controlled by your will, that is your estate. Not every asset you own, not everything you own is part of your estate. There are probate assets and non-probate assets. An estate asset is anything that's held in your individual name on your death. So that could be a bank account, it could be your car, it could be a checking account. And maybe it's easier to explain what is not part of your estate. So when people talk about avoiding probate, they're talking about changing titling or holding assets in such a way that it doesn't become part of the estate proceeding. So that might be anything with a beneficiary designation. So life insurance, investment accounts, 401ks, pensions, any bank account that you co-own with another person. So a jointly held bank account. So a bank account that you are on that is co-owned with you and a child, for example, would be a non-probate asset. It wouldn't be controlled by your will and it wouldn't become part of the estate proceedings. Life estate deeds, trusts are non-probate. Something that has a pay on death designation. And one thing about that is the MBA has a form now that you can put a beneficiary on an automobile. So that might be helpful to keep in mind. So that's what goes into your estate. And when you draft your will will control only those assets that are part of your probate estate. So you would name your beneficiaries in there. You could also put information about specific gifts that you want to give people, family heirlooms, gifts to charity, that sort of thing. You could also include your burial arrangements. I think those also should go in your advance directive, and I'll talk about that when I get to my discussion on advance directives a little bit later. But you could put your funeral and burial arrangements in there. A really important thing that your will does is you can name a personal representative. So under Maryland law, there's a priority. So certain people have priority to be appointed as personal representative. And all children have the same priority. And if you don't have a will, then any child could petition to be named as personal representative. That role is also called executor, but in Maryland, we call that role the personal representative. So the person who's going to take charge of all your assets and then be in charge of paying bills and satisfying claims and then distributing money, the assets where they belong. Children all have the same priority in having that job. I have 2 kids. One child is really great with money, super responsible. The other one, not so much. So I would really want to name the personal representative to be my child who's really great with money, as opposed to my other child who's not so great with money. If you don't do a will, both children have the same priority of appointment, and you might have the irresponsible child being in charge of all of your assets and then distributing them as distributing according to your will or under Maryland law. So that's a really important thing you can put in your will. The other thing, if you have minor children, you can designate a guardian for those children. So after executing your will, again, I really recommend bringing that to my office, and for a fee of $5. It's confidential and it's held in a fireproof, waterproof safe. And it will hold it until we are asked to remove it by you, or it's used in your estate proceeding. And it's held confidentially. My staff doesn't read your will. They just take it from you, they put it in a sealed envelope, and it stays sealed until you remove it or it's used in your estate. Sometimes people will hold their wills with important documents in their house. If you get really sick or when you pass away, your family might not know where to look for your will, or if they find your will and they don't know what it says. There's been many occasions where the wills have disappeared, and then the individual is dying intestate. So that's a really bad outcome. You could also put it in a safe deposit box, and that's a fine option. Although with the safe deposit box, you have to pay annual rent for the safe deposit box. But again, if you hold it in safekeeping, it's a $5 fee and is held indefinitely. Josh is in here helping me with something.
Somebody wants to make it a slideshow, so it's bigger.
Okay.
Okay, I can see the screen.
Okay. Thanks, Josh. I appreciate that. And I am happy to email these slides out. If you on the call wanted to share your email addresses. I also had a couple other things I was going to also share on my screen, and I can share those documents as well. So I just now don't know how to move forward on it. Oh, there. Okay, so that kind of wraps up the basics of what I wanted to cover for wills and what my office does. So the next topic I have is I wanted to briefly talk about an advanced medical directive. So an advanced medical directive is also known as a living will, and it's a document where you are able to name a healthcare agent who would then be able to make healthcare and other medical decisions for you in the event that you don't have capacity. This is only during your life. It has no effect or impact after your death. but it would enable someone to have access to your medical records, to make medical decisions. And in that document, you also are able to express wishes as to end of life decision making, like if you wanted to be have artificial nutrition and hydration, if you wanted to be put on life support, those kinds of decisions. The other thing that can go into an advance directive is your funeral wish, the wishes for your funeral. You can also put them in your will, and that's probably not a bad idea. But many times you've already had your funeral before people are pulling out your will to see what you wanted to have done for your funeral. So the advance directive, again, is for your lifetime, and you can put your your wishes for your funeral in that document as well. And I wanted to share on the Maryland Attorney General's website. Hold on, let me just see. I wanted to share this document here. So on the Maryland Attorney General's website, they have a really great self-explanatory advanced medical directive form. And it has really a lot of instructions and questions, but then they also have a form you can fill out. And unlike the will, the advance directive doesn't require an attorney to draft it for you. So this is what the form looks like. And I will show you on here. Let's see here. After my death, there's a section in here that talks about organ donation, donation of if you wanted to donate your body, if you have funeral arrangements. And you can see it's pretty self-explanatory, and you can write in your funeral direction. So anyway, it's a really useful form, and it's free on the Maryland Attorney General's website. And the slides do have a link to it. And I can also send the link, if I get your email address, I can send the link to that form. Okay. So finally, I wanted to talk about powers of attorney. When people get estate planning done, a lot of times attorneys will recommend a power of attorney. And again, there's a form for this as well, but I wanted to just explain what it did and kind of give some warnings about it as well. So it's a document and can only be used during your life. So the authority that you grant ends at death. You can't, if you appoint a power of attorney, in fact, they are not able to serve as your personal representative. You'd still need to name them in your will. But a power of attorney is a document where you give another person the power to do things like conduct business on your behalf. So that would mean opening and closing bank accounts, buying and selling property, taking out loans, a whole lot of really significant financial matters you can delegate to your attorney, in fact. And so for that reason, you need to be really careful about who you appoint. You would need to appoint a very trustworthy person, and maybe think twice about whether you need a power of attorney. So we do see elder abuse in our offices, and I'm going to put on a slide that I'm going to share my screen and give you a referral number. And that's elder financial abuse, is where an older person trusts someone, and that person uses that trust to their own advantage and steals money from the older person. And you do see that with powers of attorney because of the amount of authority a power of attorney has to do all these financial transactions on your behalf. We do see some abuse. So while it's a really useful document, and it can be really important if you begin to have diminished capacity and you really do need help with financial matters, it would avoid having to appoint a guardian and the court process involved with that, but it also can be abused. So it's really important just to think about if you need one, and then who you would appoint. I do, if someone's pressuring you to appoint them as their power of attorney, that probably means you shouldn't appoint them as your power of attorney. So just keep that in mind. So I wanted to put that number up. So during all my presentations, I'd like to kind of, a second, let me find it. Did I share? I can't find it in my thing. Okay. Can you see this? I can't tell if you can see this number. Here it is. Okay. Every time I give a presentation, I wanted to also make everyone aware of elder financial abuse. And like I was saying, with respect to the general power of attorney, we do see this a lot in our offices, that a person trusts someone in their life, and then that person uses that trust and isolates them from family or from other members of the family that are close to the person, and then they steal money essentially from that person. And you can report elder abuse, both physical and financial, at this number with the Maryland Department of Health and Human Services. And that number is, you can see it on your screen. So I'm gonna share this pamphlet when I share the other materials from the presentation. And just be aware that if you see someone that you know is being isolated, that family is keeping you from seeing them or making plans with them, then you can report your suspicions with elder financial abuse with Adult Protective Services, and that will be investigated. And it's an anonymous complaint, so you can do it and they'll investigate, and you can make sure that the people you care about are being looked after properly. Okay, so that's all the prepared remarks I have. If I can get your email addresses, I'm going to send the slides. I will also send a link to the Maryland Advanced Directive form. I'll also send an attachment of the attorney referral list that the office keeps. And so with that, I'd really like to hear your questions if you have any. And if you don't have any, you can always email me and I will respond. Hi.
Good morning.
Good morning.
First of all, thank you for doing this talk, because I missed it, I think, at one of the senior centers.
Oh, great.
And I had a definite question.
Okay.
The power of attorney. So I don't have any relative here in the US, but I was told that the power of attorney should be given only to someone who is a US citizen. Is that correct?
I think they would want to be, the reason that it's helpful to have a power of attorney is that the person can do things locally, like go to banks and that sort of thing. I would imagine that would be more difficult if the person you name is out of the country. If they're in the country, I think there's no problem with naming someone who isn't a US citizen. But if they're not currently in the US, I think that would be, I would have to research whether it would be enforceable. If, for example, someone in another country had a US power of attorney and was trying to conduct business from overseas in the US, I think it would be hard for that to be useful.
But considering now that a lot of things are done online, you know.
Yeah, I think I'm not in my capacity. I shouldn't give legal advice. I really would have to look into that to see whether those provisions would be enforced. But I'll have to research that and get back to you. I think if something doesn't sound right to me about that, but I would have to look into it and get back to you. And I'm happy to do that if you wanted to give me your contact information.
Okay.
And I see. So if you could give either put it in the chat or send me an email. Oh,
Yeah.
Josh said, okay, I can get back to you with that question.
Okay.
Does anyone else have a question?
Actually, I have several questions.
Oh, good. Well,
unless
that's great.
So the difference between a will and a revocable trust.
Okay.
Is
so
the trust you said is a life estate deed you mentioned earlier in the talk. Is that correct? Or
okay. So a trust is a document, and it's basically an agreement between the person who makes the trust and then the person whose assets are in the trust and signs the trust. And any assets that are titled in the name of the trust are non-probate property. So they wouldn't go through the probate proceeding we talked about. A life estate deed is a completely separate, it's a deed, just like you have for your house, but it's a special type of deed where you give someone the house for their lifetime and then name who's going to get the house after that lifetime is done. So again, that would be a non-probate property. Anything that you had a life estate for and then it passed to your children, for example, that would be a non-probate asset. It wouldn't be part of the estate proceedings. There's also implications if you're trying to plan for Medicaid. So when you pass away, or excuse me, when you want to qualify for Medicaid, it's a means tested program. So they will count your assets to determine whether or not you're eligible. But your home, your personal residence is not counted as an asset for purposes of that calculation. But on your death, if you and you got benefits from that program, the state of Maryland can put a lien on that real property and get repaid for the cost of your benefits that you had during your lifetime. So one way to avoid that is to do a life estate deed. And you would have to definitely talk to an attorney that does that kind of planning to see whether that would be something that's appropriate for you. But that's why the life estate deed is sometimes popular, but it's a non-probate asset. So the trust is, again, you can put provisions in your trust about what happens to your property after your death. And all of the assets held in the trust are considered non-probate property. I know a lot of attorneys, do talks or get on talk radio and really talk about avoiding probate and how important having a trust is. In Maryland, our probate process is pretty straightforward. And when I was in practice, I didn't routinely recommend that everyone have a trust. So if you don't have a trust and you have a will, don't think you're doing something wrong. It's a decision that each person needs to make. And when all of the estates that come through here, a lot of times people have trusts, but if you don't put your assets into the trust, they're still probate assets. So you would still have to open up a probate proceeding. And most people aren't successful in putting 100% of their assets into their trust, and there's still a probate proceeding. So it's something to work through with an attorney. One circumstance when it's really important, I think important to have a trust, is if you have real property outside of the state of Maryland, in another state, you would want a trust is helpful because it helps you avoid having to open multiple estates in different states. So, but that's again, something to talk to an attorney about.
Thank you.
Any more questions?
So you mentioned about doing the same thing with the car. It's something new because that's the first time I heard of it.
Yeah, it's relatively new in the last couple of years, but the MVA has a form that you can fill out where you can name a beneficiary for your car. But it would have to be filled out before you pass away. I have a lot of people come in and want to do that after their father died, and so they could not avoid having to open an estate. But I can include a link to that in email.
Thank you.
Okay. Sir, let me look at the chat. Oh, Josh put it in the chat. And well,
Thank you.
all the stuff.
Yes,
Okay.
yeah.
Yeah, so he has the form. That's great. Thank you. Are there any other questions? All right, well, if that's all the questions, like, again, feel free to call the office, reach out to me, send me an email if any questions come up after today. But our office is in the Baltimore County Courthouse. I look forward to having everyone come in and file their wills in my office. And I hope you guys enjoy. I think the weather is supposed to be getting nicer, thank goodness.
Sure.
And anyway, we're here to serve the public, and I really appreciate everyone's time this morning and giving me the opportunity to speak.
Thank you.
Thanks very much. All right.